Yes, Mr. McLennan.
My Lords, on the question of the application of the Charter, the statute provision which is relevant to that is the EU Withdrawal Act 2018, and the page reference is 5119. And you'll see section 5.4 says the Charter of Fundamental Rights is not part of domestic law on or after IP completion day, which on its face looks like an endpoint to that. Now, what will be said about that is it has to be read subject to section 7A of the same Act and section 7A3, which is the provision dealing with other enactments and giving effect to the withdrawal agreement. So every enactment is to be read subject to subsection 2 of section 7A. We've been over that ground previously in this court in the Alistair case, but what will be said is the withdrawal agreement will have a mechanism by which the Charter has continuing effect, notwithstanding section 754. That begs rather than answers the question, because if the withdrawal agreement doesn't bring CFR back into scope through the debate we've had earlier today, then that doesn't avail at all, and section 5.4 is the predominant position. So it is still answered by the scope argument.
Yes, I see.
So that's where ultimately that goes. But again, it's quite a strong indicator of parliamentary intent in section 5.4 of the 2018 Act.
So if section 7A subsection 2 has the effect of preserving the effect of the Charter of Fundamental Rights, then by virtue of subsection 3, you have to read section 5.4 in that light.
Exactly. That's what we get to. Which takes us back to the starting point of the argument, we say. Two other points. Factual, the references Lord Stevens asked me for in respect of statute provisions. There is a supplementary interveners bundle which has the provisions for the Serious Organised Crime and Police Act at page 111. I'm not going to open that. That's section 71 of the SOCPA legislation. And then at page 62 of the same bundle, you have the Covert Human Intelligence Sources Criminal Conduct Act 2021. That's at page 62, which modifies RIPA to allow for criminal conduct authorizations. So
and the previous page reference was
111.
Thank you very much.
And final point before I pass over to Sir James is just a temporal point I probably should have made earlier. When we are debating the reach of the Article 2 ECHR provisions, and they link into this whole debate, of course the court will recall the temporal limits of that in domestic law. So it doesn't apply to cases more than 10 years back from the Human Rights Act commencement, save for some exceptional cases 12 years back. So when we're looking at what's happening with the Legacy Act, its temporal reach is 1966 to 1996. The Article 2 arguments and the link to Charter arguments, if they have a temporal limit, apply only to those cases from 88 onwards and probably from 90 onwards. So one of the applicants in this case is outside the temporal reach, and that's the Hughes applicant. But subject to those points, that's the Windsor Framework component of the case.
So in the Hughes case, you say Article 2 doesn't impose an obligation really as a consequence of the Dalton judgment.
Yes, exactly.
My Lords, I'm going to address the Human Rights Act issues. I do so on two bases, effectively, both of which sound slightly differently at the remedial stage. Firstly, in their own right, as it were, in other words, Human Rights Act arguments relating to Article 2 procedural, straightforwardly under the HRA, with all the constitutional balances that you know were built into that piece of legislation, including in particular the inability of courts, if they made a Section 4 declaration, to overturn primary legislation. That's part of the Human Rights Act, but I also do so because the essential argument that is now being raised against us that leads to disapplication, which has caused all the concern, is based essentially on the idea that despite the Human Rights Act having been incorporated, there is now, through the set of Russian dolls that my Lord the President referred to, a completely different punchline to all of those arguments in relation to precisely the same obligation, namely Article 2 investigative, as enshrined in the schedule to the Human Rights Act. But the punchline now is that the courts have suddenly been empowered through Brexit and the arrangements that govern Brexit to disapply primary legislation straight away. And it might be thought, by way of a bridge between the submissions that you've heard this morning and my submissions, that at the very least that is quite a surprising mechanism and method for legislation if one stands back from it. It's perhaps doubly surprising because I don't invite you to turn it up now, but you will recall that in, I think it was paragraph 2 of the RSEO of the Good Friday Agreement, page 10987, there was in effect a commitment in that document to, quote, complete the incorporation of the ECHR into domestic law. And the reason it was put like that in that agreement was because at that stage, the Human Rights Act had not in fact yet even been enacted. You'll remember the sequence. October, I think 1998 it was enacted, and then it commenced in relevant part 2 years later in October 2000. But what had happened by that point, which is no doubt why that provision was cast as it was that a white paper had been published, and that white paper had made it absolutely clear that the intention of the government was to present a bill to Parliament in the form in which it was ultimately enacted. In other words, including no ability in the court to disapply primary legislation in the event of a finding of incompatibility. It was therefore that scheme that was to be completed in relation to its incorporation. So that was the basic conception in 1998, which is the foundation of my learned friends' arguments that they can now disapply primary legislation. That was done, of course. The Human Rights Act was enacted in precisely that form. The rights were brought into domestic law, scheduled to the Human Rights Act, but those rights were subject to the constitutional balances, including Section 4 of the HRA, that this court knows well. And it is now said, and this is a surprise if they are right, it is now said that through the process of leaving the European Union, through the withdrawal agreement, first of all, and then through the myriad of layers of Russian doll that you have to get to, with the domestic incorporation provision in Section 7, capital A, which makes absolutely no reference to this at all, and even though all of the layers of Russian doll equally make absolutely no reference to this effect at all, both the government decided that that was the right course, and Parliament, it is said, or has to be said, decided it was the right course, fundamentally to change the basic constitutional balances in the Human Rights Act. Precisely the same articles tee up the disapplication remedy on my learned friends' opposites arguments, precisely the same provisions of the Human Rights Act. What they say is civil rights incorporates every scheduled HRA right. Well, if that's right, Parliament might be thought to be capable, at least, of being a little surprised that the legislation that apparently, on my learned friends' arguments, has had that radical constitutional effect was introduced not merely by a side wind, but in effect sub silentio, requiring a parliamentarian or Parliament itself to recognise that that's what might be being done under Section 7, capital A, and then having the ability and the will to chase through the myriad layers of Russian doll to get to the answer. If Parliament was going to make that sort of radical constitutional change, it is deeply surprising, we make the submission as a general point, that it can be taken to have chosen to do so in this way. and perhaps doubly surprising when one thinks of the broader effects that my learned friend Mr. McGlennan went through this morning. Take the Illegal Migration Act, for example. You will end up in the position in which, in relation to the Illegal Migration Act, there was one rule for Northern Ireland for migrants and another rule for the rest of Great Britain. The Illegal Migration Act is said to be in breach of the human rights, the human rights that are scheduled to the HRA. Those, it's now said, are directly effective EU rights, therefore the remedy of disapplication arises, but it only arises in Northern Ireland. So if you're a migrant in Great Britain, you go to Northern Ireland, and there it's been disapplied, whereas in Great Britain it couldn't be disapplied because the Human Rights Act contains the constitutional balance as it does. So we simply provide that as a set of bridging submissions, as it were, between my learned friend's submissions and mine. But I'm going to address directly, if I may, and on their own terms. I'll come to disapplication at the end as a discrete point, but I'm going to address on their own terms the human rights arguments, and I'm going to do so in three parts. The first part is to address the correct test to be applied to legislation. That's BB, Christian Institute, and so on. Then I'm going to deal with the two aspects that the Court of Appeal disagreed with Mr. Justice Colton about, namely next of kin involvement under Article 2 and disclosure under Article 2, picking up, in doing so, the various different ways in which those challenges are put, including the references to independence and so on that at least the respondents have sought to put at the forefront of their submissions. So I'm going to start, if I may, with the correct test to be applied, and I do so with some hesitancy because this court has been much troubled by that issue and has considered it on frequent occasions in recent years. So I'm going to take quite a lot of the underlying reasoning as read, if I may. I'm going to give you the references into the bundle of the 4 Supreme Court cases that are of interest on this subject. BB is at 6623. Christian Institute is at 5779. Safe Access Zones, the Northern Ireland Abortion Clinic case, is at 5917. And JR 123 is at page 6078. And this engages with the issue arising in different legislative contexts as to the nature of the test to be applied if a challenge is, as here, to the legislation itself, seeking, as here, a declaration of incompatibility that the provisions in that legislation are themselves incompatible with human rights. More specifically, the question is whether or when that test applies for legislation to be held incompatible. That is, the test set out very clearly in the Christian Institute case and reaffirmed after some debate, and at least the question as to whether or not the Supreme Court had taken a wrong sideways step in an earlier case, reaffirmed in the Safe Access Zones case, namely that the legislation would operate incompatibly in all or almost all cases. That was the test set out in Safe Access Zones, derived originally from Christian Institute. The sideways step that might have been a misstep was in McLaughlin, as we'll see in a moment. And the first submission we make about the test is that the key principle in our submission is that if a challenge is to legislative provisions or a legislative scheme on compatibility grounds, it must be established that it is those provisions, i.e. those legislative provisions or that legislative scheme, which is incompatible. That idea, it might be thought, was first or early bruited by Lord Hodge, with whom Lord Hughes agreed in the BB decision, which was, coincidentally, but it matters not for this purpose because I'm tracing the history of the rationale, which was about guidance, as you will recall, and in the context of immigration rules, not legislation. But BB is at, the paragraph I want from BB is at page 6646, please. And the paragraph I want is paragraph 69. And you'll recall the setting, as you read that, which was that there had been a requirement introduced in immigration rules imposing a requirement for an English language test to be taken and passed, and the extent to which there might be excuse for not doing so exceptionally, and the guidance covered the exceptions. The problem, in essence, being that there might have been a significant number of cases that did not fall within those exceptions, but where nevertheless tuition abroad was out of reach, whether practically or for financial reasons, for individuals. But you'll see the way in which the point is put by Lord Hodge, with whom Lord Hughes agreed, at paragraph 69. The court would not be entitled to strike down the rule unless satisfied that it was incapable of being operated in a proportionate way, and so was inherently unjustified in all or nearly all cases. As a result, the appellants failed to show that the rule itself is an unjustifiable interference with Article 8 rights. So those ideas of incapability, inherently unjustified, focusing on the rule itself. That key rationale for the principle, we submit, was picked up and identified when the matter was reanalysed following Christian Institute by Lord Reid in particular in the Safe Access Zones case. If you go back to page 5917, you will see the beginnings of that analysis with the title above paragraph 12, two-thirds of the way down page 5917. And what the court does, what Lord Reid does in that judgment, as you see at paragraph 13, is to recite the test that the court had arrived at in Christian Institute, which is quoted at the end of paragraph 13 over on page 5918. Can I just invite you to remind yourselves of that? And the question ultimately, which I don't need to spend long on because the clarification is clear, the question particularly in that case was whether or not, in effect, the reduction of that test, of the rigour of that test that you see from McLaughlin, particularly at the bottom of page 5981, you'll see that what was being said in McLaughlin by Baroness Hale was, it is enough that it will inevitably operate incompatibly in a legally significant number of cases, that it might be thought as a matter of language and substance is very different from the rigour of the test of in all or almost all cases that the court had identified in Christian Institute. And Lord Reid for the Supreme Court clarified that the test was indeed the one set out in Christian Institute at the end of paragraph 13. But the particular reason I wanted to go to this authority and this analysis was because Lord Reid analysed with some care the rationale for the approach in Christian Institute. What was the basis for getting to all or almost all cases as an idea? And that is dealt with in para 14. The rationale of that approach, that's the all or almost all cases approach, is that where there is an ab ante challenge to a legislative provision, that is to say, so he's defining the ab ante, what ab ante means, that is to say, a challenge to the provision in advance of its application to any particular facts. The striking down of the provision is only justifiable if the court is satisfied that it is incapable of being applied in a way which is compatible with Convention rights, whatever the facts may be. If the legislation is capable of being applied compatibly with the Convention, then it will survive an ab ante challenge. So that was the key rationale for the principle identified by Lord Reid for the court in safe access zones. Defining what was meant by ab ante, as I've said, putting the same point another way as Lord Reid did, is the legislation incompatible, whatever the facts may be, to take his phrase. Only then and only if the legislation is, quote, incapable, the echo of the language from Lord Hodge in Beebe, of being applied compatibly, will it be that the legislation is incompatible? And Lord Reid returns to the same idea in the analysis of the facts of McLaughlin. And he does that at paragraph 17 on page 5919, if I can just invite you to cast an eye down that paragraph. You see the analysis. If you set up the rule in that way, it's going to apply in any case concerning the denial of the same allowance for the same reason. So it applies across the board. So that you don't get the sort of ab ante problem where facts may be important, or the fact patterns that flow through the legislative provision may be important. The critical distinction is in the final sentence. And you see it particularly in the second half of that final sentence of paragraph 17. If that were so, then no issue would arise of the kind which arose in Christian Institute, where the measure was not inherently incompatible with the Convention, but might be applied incompatibly in particular cases. So that's the same idea explaining McLaughlin and the outcome in McLaughlin. And that explains the question raised by Lord Reid in paragraph 17 about the court's analysis in McLaughlin. Compatibility there didn't seem to depend on the facts of particular cases or fact patterns in cases to which the legislation applied at all. And that was because the vice of the legislation in McLaughlin was that it applied a rule, there denying allowance for children of a surviving parent, to the detriment of the survivor and the child on the basis of marital status alone. And that rule would, it might be thought, apply in any case concerning the denial of the same allowance for the same reason as the court put it. If the scheme is set up, if the legislative scheme, however, is set up, and compatibility is or may be dependent on fact patterns to which it applies, it will not be the scheme itself which is at fault. And that's what this analysis is trying to identify. Is it the legislation itself which is at fault, or inherently defective, or incompatible? The legislation may be compatible, even though it may throw up some, perhaps many cases of incompatibility where it applies. It must be shown, if you're challenging a legislative scheme in this way, that the incompatibility which you allege, to put it at its simplest, is truly not fact-sensitive. And that rationale applies, we submit, so as to distinguish between causes of incompatibility. On the one hand, legislation itself being inherently incompatible, as compared to incompatibility caused by the application of it to particular facts. And once one understands that that's at the core of the distinction that was being drawn in paragraphs 14 and emphasised by reference to the facts of McLaughlin in paragraph 17, two things perhaps might be noted. The first of them is that the application of the test, or almost all cases, that test, the application does not depend on the type of legislation. Indeed, in Beebe, precisely the same reasoning was applied to guidance that was the subject of the analysis in that case. So the principle is not restricted, we submit, to compatibility challenges to devolved legislation. It isn't a principle that, on its rationale, applies just to devolved legislation or to challenges that are based on the constitutional constraints in devolution legislation, ensuring that local legislation cannot be incompatible with the ECHR. Those types of case, in other words, references to the Supreme Court to test the compatibility of legislation, are perhaps paradigm examples of what might be called loosely ab ante challenges, because they involve challenges to the compatibility of proposed devolved legislation in advance of them even becoming legally effective, and in circumstances in which that is the scheme set up under the devolution legislation. That devolution legislation does not set its face against legislation where the fact patterns arising under it might be incompatible. It does set its face against legislation which is itself incompatible, a well-known distinction in that context. But my point, my first of the two things to be noted, is that those are features of the devolved legislative schemes and the challenges that have come forward on that basis. But the application of the principle based on the rationale that we saw in paragraph 14 of safe access zones is not confined to devolution legislation. They are simply examples of the operation of that broader principle. The second point to note, once one understands that rationale, is that the application of the all or almost all test does not depend on whether legislation is in force or has been commenced. Ab ante is not a reference to that. It isn't about whether it's a current scheme that is being or is capable of being applied to people. That is perhaps evident from the fact that in BB the rule in question and its exceptions were in force. But it simply doesn't, it isn't only, the ab ante principle is not only applicable when the legislation is simply uncommenced, as it were, or in the devolution context, where it is being subject to challenge prior to it coming into force under the constitutional legislation that governs that. The distinction drawn by Lords Reid and Hodge in the two cases we've been to bases the rationale in the way that's just examined and is not dependent on whether the legislation has current legal force, but rather on the nature and impact in terms of incompatibility. So that's the first submission we make. The second submission we make is that that rationale found in paragraph 14 of safe access zones is, we submit, very soundly based in constitutional principle. It's of critical importance under the scheme of the HRA to establish whether it is the legislation that is incompatible, or whether the position is that the legislation is itself compatible, but there's incompatibility or potential incompatibility on the facts of a particular case governed by the legislation. And that is in part because, under the scheme of the Human Rights Act, the remedial scheme and all the things that flow from that, Section 4, Section 10, and the ability to introduce remedial orders and all of that, they all flow from that distinction, that ability to identify that it's truly the legislation that is at fault. And we also submit that that distinction, that Christian Institute Safe Access Zones test, reflects other well-established constitutional limits on the role of the court. It isn't, for example, generally the role of the courts to issue advisory opinions on hypothetical or academic cases, lacking in specific, if relevant, factual contexts. And abstract ab ante challenges come close to being a species of that. But also, you will recall Lady Hale, perhaps in Chester, paragraph 100, don't invite you to turn it up now, 6732, paragraph 100 of Baroness Hale in Chester, that Strasbourg also does not usually decide cases in the abstract, but by reference to the particular case of the applicant. And the safe access zones test and approach, with that rationale underpinning it, is designed to ensure that domestic challenges do not stray too far from that or take the domestic system beyond Strasbourg. The third submission is really by way of focusing on a particular category of case which has caused the courts to scratch their heads a little bit, and it goes to the structure of the legislation and exceptions, or the lack of exceptions in particular legislation. You could have cases in which the incompatibility is said to flow from the fact that the legislation's rules apply without exception. or without the ability to operate to consider the possibility of exceptions. In other words, it sets absolute or hard-lined rules in the legislative scheme itself. And perhaps a paradigm example of that is the McLaughlin case. It was exactly that point, that special feature that was being drawn out by Lord Reid in paragraph 17 of the Safe Access Zones case that we've looked at, hence his analysis there. But it often arises, as you'll appreciate, when it is said that the legislation, as it was, for example, in the VAT on school fees case, that was the subject of a recent divisional court judgment, and it's referred to in some of the parties' cases. It often arises when it is said that the legislation needed to allow for exceptions or would be either discriminatory or non-compliant with the less intrusive measure requirement under the proportionality aspect. The key question there will be whether, as is often the case in those examples, it is the legislation's structure, with or without the ability to carve out deserving exceptions, which is the problem. You go back to the same essential point. Is it a problem that is inherently part of the legislative scheme? And we submit that that is the way in which this principle works, and that is the way in which you decide whether or not you are dealing with a context or a challenge in which what has to be demonstrated by the challenger is that there will be a compatibility in almost all cases. It fundamentally depends on that distinction. Is it the legislation that is inherently at fault, irrespective of the facts? So the facts really drop out of the picture because the fault is the legislation's. That's the distinction that we say underpins this principle and everything else that follows from that. How does that apply here? The challenge here, as you know, is to the legislation as such. And the declaration of incompatibility granted by the Northern Ireland Court of Appeal, I invite you to turn it up, see page 344, reflects that. It's against the legislation itself. There's no reference to any individual case or to a limited category of cases where that arises. The core conclusions reached were that the provisions of the legislation setting up ICRIR, if I can call it that, could not operate compatibly with A2, A3, where they're replacing inquests, because of the issues to which I'll come, with the next of kin and or disclosure. It was not said that investigations by ICRIR had been incompatible because they were not effective, to use that key ECHR test, which we'll come to when we examine the requirements of A2 procedural in individual cases. Nor was it said that on the facts the next of kin had not been sufficiently involved or had not had access to particular documents without which they couldn't participate properly. By definition, the ICRIR work had not been undertaken yet. Indeed, as one sees from the judgment of Mr. Justice Colton, the very procedures which ICRIR were to apply were within the bounds of the statutory powers and discretions created by the Act, were themselves still the subject of ongoing work and were a work in progress. See, for that purpose in particular, the judgment of Mr. Justice Colton, paragraphs 339 to 357 is a little chunk that gives you that still work in progress point, page 553 in the bundle. And I make this point entirely clear because our case is not, as appears to be assumed by the respondents, that the present context is within the principle in safe access zones because, as they put it, there has not yet been a complete investigation of inquests. That's paragraph 47 of the respondent's case at page 95. That's entirely the wrong focus. It's not our case at all. The legislation, which is the subject of the challenge, sets up the schemes of investigation that are to be undertaken by ICRIR. It is those investigations that have to be established as being incapable of delivering an Article 2 compatible result. And the challenge and conclusion of the NICA, the Court of Appeal, was based on the conclusion that the legislation itself was incompatible. They gave 2 reasons for not applying the test that we've seen from safe access zones. Firstly, they said, and I quote, the ab ante test does not apply because Articles 2 and 3 concern absolute rights with no proportionality balance. That was the reason that they gave. And we make 2 submissions in response to that conclusion by the Court of Appeal. Firstly, it assumes that the all or almost all test applies solely on the basis that, and to cases in which, proportionality is involved. And that is a central theme of the response produced by the respondents to our case on this aspect. And we submit it is wrong. The test applies, as I've indicated, to ensure that legislation is only held to be incompatible if it is the legislation that is inherently defective or at fault, as compared to those situations in which the run of cases go through its structures and some may not generate incompatible outcomes. Proportionality analysis, which most if not all of the cases have considered to date, is simply an example of a case in which powers conferred by legislation can be exercised compatibly or incompatibly on the facts. But proportionality is not the only context or basis on which it is necessary to determine if it's the legislation itself which is inherently incompatible or not. And of course you could have a claim, I note, that the very structures or provisions of the legislation are themselves necessarily and in all cases incompatible. No difficulty with that. But the distinction is not proportionality or no proportionality. So it's not a distinction between the articles in question having proportionality built into the analysis or not. It is a distinction, as explained in safe access zones, between legislation which is inherently incompatible and legislation which, as Lord Reid put it, might be applied incompatibly in particular cases. So that's the first answer. To the extent that they thought this was a principle that only applied when proportionality was strictly an issue, they were wrong to do so, and they failed to understand or recognise the principled underpinning for the principle as explained in paragraph 14 of safe access zones. The second submission we make in response to that conclusion of the Court of Appeal is that it in any event mischaracterises the obligations, the relevant obligations under the Convention that were in question in any event. Of course, in certain respects, particularly in relation to Article 2, when one's looking at Article 2 and 3, in certain respects, Articles 2 and 3 are nominally absolute. But, as is also trite under the Convention jurisprudence, they have expanded beyond their express boundaries. And they've expanded beyond their express boundaries because they have been read by the European Court in Strasbourg alongside the obligation in Article 1 to secure rights and obligations to people within your jurisdiction. And what that has led to is the implication of rights and obligations. In the present context, incompatibility is said to derive from what are said to be necessary ingredients of compatible investigations into deaths that have themselves arguably breached the substantive A2 or A3 obligations, to use that well-known taxonomy. So the question is as to the nature of those obligations, in other words, the investigative obligations under Articles 2 and 3. And that is a subject which both the European Court and the Supreme Court, and all levels below the Supreme Court, have considered on many occasions. The key point, perhaps, is that the matters of concern to the Northern Ireland Court of Appeal are not expressed as uniform rules or as absolute, but on the contrary, as subjecting that investigative process to a legal standard, and I'll come back to this, the legal standard being the effectiveness of the investigative process, with ingredients that are fact and context dependent. To note, in particular, all of the key principles in one place. If you take up the McQuillan case, which some of you will recall, and you go to page 7781, if you would, in the bundle. This is the judgment of the Supreme Court in McQuillan. It's a judgment of Lord Hodge, Lord Lloyd-Jones, Lord Sells, Lord Leggett, with whom Lord Kitchen, Lord Hampden and Lord Burrows agree. So the full judgment of the full court, in effect, and a seven-person court. You'll see the principles set out at paragraph 109, and if you just cast your eye down them, they're all immediately recognisable. But the reason I'm going here is to illustrate that the investigative obligation and the ingredients within that investigative obligation are deliberately set up in the Strasbourg case law to include a whole series of relative concepts and relative ingredients. And one sees in particular from paragraph 109.5 that there must be a sufficient element of public scrutiny of the investigation or its results in order to secure accountability in practice. The degree of scrutiny, as is expressly acknowledged at Roman 5 on page 7782, the degree of public scrutiny that is required will vary from case to case, but the next of kin must be involved in the procedure to the extent necessary to safeguard his or her legitimate interests. So in the ingredients themselves, you've got this built-in set of relative concepts, and you've got the clearest possible and unsurprising recognition that flows from that, which is it all depends on the facts of the case. So even when you get, if you look at the public scrutiny obligation, it's a sufficient element. If you look at the involvement of the next of kin, it's to the extent necessary to safeguard his or her legitimate interests. So you get that from both of those. So it isn't a uniform set of rules. They're expressed in relative terms. So the Article 2.3 obligation is not absolute, but intensely fact and context specific. And that's rendered all the clearer because of the identification from the Strasbourg case law that the absolutely central and overarching concept is whether or not the investigative process is effective. It's that adjective. And one sees that from Roman 6 as an obligation to ensure that the investigation is effective. And then various aspects of that, that's taken from Jordan and Ramsarai and Nachova. Another aspect of that is identified in Roman 7. Another aspect of an effective investigation, which is a focus of one of the central issues in these appeals, is that persons responsible for carrying out the investigation must be independent of those implicated by the events. And then making the point that even in the context of independence, that is a concept which is likely to be fact-dependent, because it's all about practical independence. And we'll see when we get to it, as we will in 1 second, but we'll see when we get to it that the court identified, based on the Grand Chamber judgment in Tunk, that independence for the purpose of Article 2 was, if I can put it this way, a much more fact-specific thing than the concept of independence in Article 6, where very often what is done is to look at things that apply to all people like judges, namely security of tenure, length of tenure, grounds for removal, that sort of thing, structural independence. This Article 2 aspect is much more malleable, much more flexible, much more fact-dependent.
Just remind me
Yes.
as to what the involvement of the families are in before the Commission. They can make a request and they can ask questions at the beginning. What role do they play thereafter?
Well, my Lord, I don't want to duck it now, but it's quite a big topic, and obviously it goes to the first of the substantive grounds I'm going to address, which is next of kin, and I was going to take you through the various legislative provisions that bear on that. Can I take it at that point? So just to finish this point, if I may, 193, if you go forward at page 7809, and you'll see that there the Supreme Court is focusing on the convention requirements for an independent investigation under 2 and 3. So that was a key issue in the appeal. You see that title above paragraph 193, and then you have a section that follows that. And the first point that is made is the one that I flagged earlier at 194 and 195, based on Tunc and Turkey, which was a Grand Chamber case. C194, so Tunc and Turkey, as the court found, was a decision of central importance in this aspect. That's because it's a judgment of the Grand Chamber where the Strasbourg Court undertook to give general guidance on the requirement that an investigation be independent. Then you draw the contrast between Articles 2 and 6, and the punchline of that is the final sentence of 195. The adequacy of the degree of independence, this is in the context of Article 2, is to be assessed in all the circumstances of the specific case. And then the court decided to quote in full from the Tunc judgment. And can I invite you in particular to remind yourselves of the passage that you highlighted at 225 of Tunc over on the next page, 7811. I won't read it out because it's length, but if you could just remind yourself of 225 of Tunc. So you can see that flexibility, as it were, reiterated by the Grand Chamber and built in. They're now no longer even ingredients, they're criteria, all of which feed into a fact-specific assessment of effectiveness, including in relation to something which might be thought to be relatively hard-edged, like independence, but not even that. It's all in the melting pot until the end. And what that recognises, what that approach leads to, was then identified by the Supreme Court in the final section of paragraph 196 on page 7811. This approach recognises rarely possible to determine whether an investigation will not be effective because of lack of practical independence and so on, till it's been completed. And you see that idea picked up in paragraph 199 by reference to Lord Kerr's judgment when he was Lord Chief Justice in Northern Ireland in Kelly. And you'll see in 199 the Supreme Court describing that as having adopted the approach, reading 3 lines into 199, of requiring the completion of an investigation before forming a judgment on its independence and effectiveness, where he was satisfied that it had the capacity to be effective. And at that point, my notional ears started pricking up, because that idea of capacity is exactly the same idea that underpins safe access zones. It's that idea that if you've got facts, you better wait and see. And we have here plainly got facts that need to be determined because of the flexibility of the test of effectiveness, all of the things that feature into that. And the only circumstance in which you could conclude in advance of the end of that process, i.e. after you'd had an actual ICRIR investigation, that the thing had not been effective, would be if you could be satisfied that it could not be, didn't have the capacity. And we echo back in almost all cases if it's the legislative scheme that's said to create that. And that idea of capacity versus waiting to see what the facts throw up before judging effectiveness, that echo into this principle, you see is carried through that paragraph So 199, you see capacity in the first line on page 7812. You put a notional circle around that. You see it referred to again in the sentence before the quote in para 199 between C and D, being satisfied that the investigation had the capacity to fulfil the procedural requirements. You dismiss the application for JR, which was brought before the investigation had been completed. You see it in the quote from Lord Kerr's judgment in Kelly. It's highlighted in that quote, as you see, penultimate line of the quote, emphasis in the original. And then the court picks up on that idea in paragraph 200. Can I invite you simply to read the last sentence or two, beginning just above the letter H, where you see the words, I agree, on page 7812. The court should generally intervene before the conclusion of an investigation only, and so on. Can I invite you to read to the end of the paragraph? And indeed, with all of the notes of caution, I'm going to put that judgment away, but with all of the notes of caution as to the read across between Article 6 and Article 2, including in particular in relation to independence here for all the reasons given, but with all that those notes of caution, the echo and the reminder goes way back into the idea that was explored by Lord Bingham, as you will recall, no doubt, in Brown and Stott, the drunken driving case in the early days of the HRA, where Lord Reid said, on absolute versus non-absolute obligations, where Lord Reid said essentially Article 6 imposes an absolute requirement for a fair trial. You can't derogate from that. The trial's got to be fair or it hasn't. But the ingredients of that are flexible and will depend upon the context. It's a similar sort of idea, but this time in the context of Article 2.
Lord Bingham, I think. Lord Bingham.
Lord Bingham, I'm so sorry, I'm getting my presidents mixed up. But yes, Lord Bingham and Brown and Stott. So that was the first thing that the Northern Ireland Court of Appeal held, that it wasn't an ab ante case because it concerned absolute rights with no proportionality balance. My respectful submission is that does that get the understanding of proportionality as the yardstick wrong, but it also mischaracterises the obligations in question, which are themselves obviously and clearly fact-dependent for all the reasons I've given. The Court of Appeal reached an alternative conclusion, which was that even if the all or almost all cases test was met, they concluded that the test was met because the problematic elements, as they described them, applied to all or almost all cases where inquests were to be replaced by ICRIR, and so, as they put it, they related to an entire category of cases. And in answer to that, we say that the legislation sets up a new regime with ICRIR at its heart and having the powers that it has. It self-evidently applies in that situation and in all cases now moved into that new regime. That was Parliament's intention, with all the benefits that it saw as flowing from that. And it's to be borne in mind that the Court of Appeal at this stage is assuming that the test applies. In other words, it must be shown that in all or almost all cases, the legislation will itself lead to incompatibility. That involves asking whether the problematic elements they identified, next of kin involvement not sufficient, disclosure problematic, they concluded, would inevitably lead to incompatibility in all or almost all cases. That was the test that had to be satisfied if they were applying it. And that isn't answered, we submit, by pointing to the fact that the legislation will apply to cases in which ICRIR displaces inquests. That's about coverage of the elements, not their impact in terms of compatibility on individual cases flowing through the system. The compatibility of legislation requires focus on properly appreciating the nature of the obligation imposed under Articles 2 and 3 procedural, and then asking whether having the elements in question will inevitably lead to incompatibility in all or almost all cases. And there are, we submit, very, very clear answers to that. The nature of the obligation we've explored from Macquillan and is very clear. There's nothing hard-edged or uniform or absolute about it. The test is effectiveness. with all of the other elements feeding into that as criteria or ingredients, and the elements themselves are fact and context dependent, as the Supreme Court emphasised, sufficient involvement, necessary to protect their legitimate interests, and so on. And once that is appreciated, the key and simple point is that it was simply impossible to conclude, in the absence of any investigation at all by ICRIR, that all or almost all cases flowing through that system would fail to pass Article 2 ECHR muster. Simply not open to the Court of Appeal in Northern Ireland so to conclude, and not answered by using the language they did about entire categories of cases. So that's what we say about the application of that Christian Institute test. Can I turn then to substantive Article 2 and the ingredients of substantive Article 2 and how that all works? And I do so emphasising initially two very short points. The first of them is the one that was made at the tail end of his submissions by Mr. McLean this morning, which is that the ICRIR, the ICRIR body, has been set up to deal with all cases since 1966. And that's because troubled is a defined term. The Troubles is a defined term in Section 1 of the Act, and it extends from there to, I think, 1996 as a period. And, of course, we know from McQuillan itself that the HRA is simply inapplicable on temporal grounds if you go back more than, assume for the sake of argument, 12 years. So a chunk of these are going to fall out anyway and are not going to be applied, which it might be thought is itself problematic for the all or almost all approach. And might also be thought to be intensely problematic if people are trying to build in the same rights with different outcomes through the doctrine of direct effect. I'm not sure how the temporal position would work in relation to directly effective rights of this kind. Perhaps it would come with it, perhaps it wouldn't. Anyway, that's the first point. The second point is an even shorter one, which is that the ICRIR body has been set up, as is required under the legislation itself, to be run by a person who has held high judicial office. And in the case of ICRIR, that person is Sir Declan Morgan, who is the commissioner. And so it has that august head, as it were. And he is, or he will, have to formulate some of the procedures that I identified as being work in progress from the judgment of Mr. Justice Colton at some point, which makes it even more surprising that it can now be said that there is incapability flowing from the scheme of legislation of satisfying the Article 2 investigative process. And if that is right, then the principle in McQuillan that we saw, para 199 and following from Kelly, is squarely in play. The first of the two bases of challenge under Article 2 procedural is next of kin involvement. I've been through the nature of the relevant ingredient, or criteria, to use the word from Tunk. Effectiveness in the individual case is the test, and one of the criteria against which you judge that is whether or not the next of kin are involved to the extent necessary to safeguard their legitimate interests, with all the fluency that is built into those concepts of relative necessity and legitimate interests. And that, of course, is an aspect of and ties into the also relatively defined doctrine of sufficient public scrutiny. The Northern Ireland Court of Appeal concluded that the nature of effectiveness plus next of kin involvement created, in the context of what they described as complicated historical cases, a set of hard-edged requirements. Specifically, in all cases, it appears, or almost all cases, oral evidence with cross-examination in an adversarial process, with the families represented by lawyers of their choice, and with the state funding that, in effect, trial exercise, adversarial trial exercise, through the provision, the mandatory provision of legal aid. One sees that in the Northern Ireland Court of Appeal judgment, particularly at paragraphs 218 to 220. And we submit that there is no justification for that conclusion. And we make 5 submissions in relation to that. Firstly, to conclude that that is what is required in order to satisfy those criteria, still less the overarching and governing criterion of effectiveness. To do so goes very considerably further, even than the conclusions the Supreme Court reached in Finucane. And I say even because Finucane, as you will well recall, evidently involved extreme facts and allegations calling for what might be thought to be a high process on the facts. Finucane, if I can invite you to take it up, is at 7655. And I don't want to take long with the facts, but you can see just by a cursory glance, for those of you who were not already on the court, I think 2 of you were on the court, but you can see from a cursory glance down the headnote at page 7655.
I think I'm the only survivor.
I think Lord... Oh yes, perhaps you are, sorry, one of you, sorry, I misread Care for Reed, yes. I think it is you.
I think you appeared in front of me. I think you appeared in front of me at first instance.
My lord, I did. I'd rather forgotten that. Yes, I did. I think it was the first case I ever did in Northern Ireland, actually, so pleasure it was. Anyway, you see the nature of the facts, before we get too sucked into that debate. I wanted to go, if I may, to 134, para 134 in the court's judgment. And that is on page 7689. Because what the court is here starting to do, the court finds a violation, or they find that the Article 2 investigative obligation had not yet been satisfied. The argument that we mounted was that the De Silva review had been enough, had been sufficient. The court disagreed, and so you're looking to see the features that were held to be to lead to the conclusion that Article 2 had not been satisfied because the De Silva review hadn't done the business. So 134 is the starting point, if I can just invite you to read that to yourselves. You can leave aside the jury point between B and D on page 7690. But it's really that bit at the beginning, the first half of 134. Didn't have power to compel attendance of witnesses. Those who did meet him were not actually subject to testing by way of challenging probes to the veracity and accuracy of their evidence. Potentially a critical witness was excused attendance for questioning by Sir Desmond. All of those attest to the shortcomings of the review as an effective Article 2 compliant inquiry. And then you see this...
that aren't to this standard of concern. What is the role that should be played by the next of kin?
Well, my lord,
not this. What is it?
My lord, we submit that that depends ultimately on the particular investigation that is being undertaken, the particular inquiry that is being done.
Give me a few examples.
They have the ability to request a review. I think they have the ability to see the report when it is done. The extent to which they are involved in the actual process itself will be the subject of discretionary judgments that will be made by ICRIR. That's essentially what it comes to. I'll take you to the relevant statutory provisions in a moment, but that's it in a nutshell. But the reason I go to Finucane, you'll understand and you will recall, but the reason I go to Finucane is because these were the problems that the Supreme Court identified. I'm going to them as much for what is not there as for what is. What is not said, even in the context of Finucane, is you need what the Court of Appeal in Northern Ireland decided was needed in every single case going through ICRIR, namely families represented by lawyers, paid for by the state through the provision of legal aid, ability to cross-examine every witness or every witness' relevance, and so on. Full-blown trial process, in effect, a replication of the inquest process. And I say replication of the inquest process in circumstances in which the legislation, at its core and at its most fundamental level, Parliament decided it wanted to replace that system with something which was inquisitorial, knowing that in the past, inquisitorial, and indeed across Europe, in very many contexts, inquisitorial is the answer and is sufficient. I don't know how many European states provide legal aid for lawyers to cross-examine people, but these will be, if they are truly ingredients of any compliant Article 2 investigation, the logic of that means that they've got to apply across Europe, across contracting states. Might come as a great surprise in France or elsewhere, it might be thought. Anyway, back to Finucane, page 7691. You see the same point essentially that was teed up in 134 being reprised in the conclusions section. If he'd been able, I'm reading from about 5 lines into 140, if he'd been able to compel witnesses, if he'd had the opportunity to probe, if he had had the opportunity to probe their accounts, perhaps note, if he had been given the chance to press those whose testimony might have led to the identification of those involved in targeting Mr. Finucane, the evidence handler had been obtained, medical evidence as to incapacity, and so on. Absent those vital steps, the conclusion that an Article 2 compliant inquiry into Finucane's death not taken place is inescapable. I wanted to finish the Finucane judgment by inviting the court to recall, because again it feeds into this same theme. If you go forward to paragraph 153 at the bottom of 7693, you will see the disposition of the appeal. And what the court decided to do, perhaps unsurprisingly, but relevantly for our purposes, was to declare that there had not been an Article 2 compliant inquiry into the death of Mr. Finucane. And then they say in terms, it does not follow that a public inquiry of the type which the appellant seeks must be ordered. It's for the state to decide, in effect, how to do that. And so the short points from Finucane are that there is no suggestion, even in the context of those facts, that the sort of process that the Court of Appeal were envisaging would happen in every ICRIR case as a necessary, essential ingredient or concomitant to an Article 2 satisfactory process. None of that. Instead, on the shortcomings identified, you'll see the things that cause concern. There was no call for that sort of process, and if the Supreme Court had considered that that was necessary, it would undoubtedly have said so.
What was the public inquiry of the type which the appellant seeks? Because there was a long dispute about the power of the Secretary of State under the Inquiries Act 2005 to withhold documents, and that was the reason why the Finucane family didn't engage with a public inquiry.
My Lord, you're right in your recollection. I think the central problem, which had gone on for years, as you will recall, but the central problem was Section 19.
Yes. And were they seeking a public inquiry without Section 19, or was a variation on Section 19?
Well, I'm not sure precisely what the position was in relation to that by the time it hit the Supreme Court, is the answer to that. Yeah. Because they did waver a bit in relation to that. They started off big solid against Section 19 or anything to do with anything that had Section 19 in it. And at some point in history, and I can't, I'm afraid, quite remember when, they moved to a position of saying, well, all right, we'll have a public inquiry. Right. I suspect it was during the litigation. It might not have been before my Lord sat on the case, but so I'm not entirely sure what the answer to that is. But anyway, the core point is that it's not, I don't think one can restrict it to that. They make the negative declaration, in effect, and don't do any more. And what they certainly don't do is to suggest that you need legal aid, cross-examination, own lawyers, the full-blown adversarial process. And on the contrary, the suggestion from the judgment is that an inquisitorial process, if only it had been conducted differently, would have done. And that, it might be thought, is much more consonant with the idea that these requirements have got to work across the contracting states and the reach of all the Council of Europe states to which the Convention applies. But the implication, the clear implication I submit from the judgment is if only De Silva had done it differently, called the witness or called for medical evidence, himself probed, that would all have been fine. But he didn't. So it goes considerably further than Finucane is the first point. Second point in relation to the Court of Appeal's reasoning is that it's not clear or principled to apply the requirements that the Court of Appeal wished to apply to, quote, complicated historical cases. It's entirely unclear what that would entail. And I've already made the point that it might entail one rule for one complicated historical case and another for another because of the temporal reach of the Human Rights Act. But it's entirely unclear anyway what that would entail. But where's the boundary? When is something a complicated historical case? Where does that come from? It's not principle, we submit, because presumably that idea is designed as a moniker for complexity, but Finucane, it might be thought, was pretty complex. And of course, complexity is but one factor feeding into the ingredients laid down by the European Court for a compatible Article 2 investigation. And there is nothing in the Strasbourg case law that suggests that in complex cases, just to take that as a neutral idea, you needed an adversarial procedure with legal aid provided and cross-examiner witnesses in all cases, in effect as a sine qua non of effectiveness. There's absolutely no suggestion of that. Indeed, it would be antithetical to the basic flexible principles that the Supreme Court derived accurately, we submit, from the Strasbourg case law in McQuillan. Third point is that the Northern Ireland Court of Appeal requirements are said to apply across the board, and that covers the range of cases where ICRIR is taking over from inquests, and its logic would apply to impose that set of requirements, it appears, whatever the facts and circumstances. In other words, even in a simple case, even in a case which did not have a great deal of complexity about it, it seems to be a requirement or set of requirements that apply to all complicated historical cases. Possible to see how one could predictively come to the conclusion that even in those sorts of cases, those features would be necessary in all cases. Fourthly,
Sir James,
oh, sorry.
I don't expect you to answer this just now.
Yes.
I'm just wondering, the Committee of Ministers were involved with the government in looking at the legacy legislation, weren't they? Because, of course, they're supervising the implementation of judgments.
Yes.
It just occurs to me to wonder whether they express any concern about the inquisitorial rather than fully blown adversarial aspects of the procedure.
Can I check that?
Yeah.
I know they were involved in part in the Finucane case, as one saw, because one of the issues that was being considered there was that...
Yes, because I think your point about the peculiarity from a European perspective of our obsession with adversarial procedure
might strike a note.
may have some force.
Yes. But let me check that, if I may. I'm sorry, I don't know the answer immediately. It ties in, perhaps, or leads in at least, to the fourth point, which is that the basic idea in relation to the Strasbourg jurisprudence, reflected in our domestic jurisprudence accordingly, is that it is for the state to decide how to set up an investigation. That's a slightly different point, obviously, to the myriad different ways in which Council of Europe countries choose to investigate deaths or suspicious deaths or deaths in which the state is said to have been involved. But in our domestic system, it's for the state itself to decide how the investigation is to be set up, rather than insisting on a particular uniform set of rules. So that flexibility has been held up as a virtue in the case law from the early days, and that flexibility is indeed the basic message that comes through from the highlighted passage from 225 of Tunk that the Supreme Court identified in McQuillan. And of course, one of the things that no doubt the state will be well aware of, and one of the things that no doubt underpin the basic conception of the 2023 Act, is the idea that it was time to move on, it was time to draw a line, and it was time to stop the endless litigation, endless, complex, prolonged, costly litigation that has flowed from all of this, and indeed that has flowed from many, many of the inquests that had been undertaken here. Parliament was trying to move to a different idea, to an idea in which there was inquisitorial process of a streamlined, hopefully a streamlined and efficient kind. And so that is an important point, both the degree of flexibility and discretion that is accorded to a state and that fundamental underpinning of the 2023 Act. The fifth point is to some extent a tie back to the points I was making earlier in relation to the all or almost all cases and Kelly and all of that, which is that there is no reason to suppose that ICRIR would not be able to conduct or complete compatible investigations. Can I just give you some references, given the time, to that? Mr. Justice Coulton, for a summary of the base legislative provisions relating to requesting a review, reporting and so on, some of the features I mentioned in answer to my Lord Stevens, see judgment, paragraph, that's judgment of Mr. Justice Coulton, at paragraph 320 to 329, you find at page 550 in the bundle. We've set out in our case at paragraph 110 the objectives, duties and powers of ICRIR under the Act, to which can be added perhaps the basic review jurisdiction in section 13.5 of the Act, page 5265, and then the duty to report in section 15.2 of the Act. And we do invite you to note in particular the powers of compulsion that the Act includes, compulsion of information and documents, including from the state. The state are relevant authorities for the purpose of section 5, which creates that compulsion duty. And relevant authorities are broadly defined to include, for example, the security and intelligence agencies, but other parts of the UK intelligence community. See section 60 for the definition of relevant authorities, page 5364. There is also power to call for the attendance of witnesses. Remember, that was one of the features that was missing from De Silva, to call for the attendance of witnesses and to probe. See section 14.1.4 at page 5268. And for good measure, ICRIR has power to carry out criminal investigations if necessary, with concomitant powers to enable them to do that. See the combination of sections 13 sub 7, section 6 and section 25. And note also, it's a point of some importance perhaps, note also the express duty. It might be thought to be superfluous, given that ICRIR, one imagines, would be a public authority and therefore bound by section 6 of the HRA, but for good measure there is a specific and express duty in this legislation on ICRIR to comply with the HRA when exercising its functions under the Act, and that must include its core reviewing function. So it might be thought to be hard on that basis alone to see how the Act could itself, and divorced from any facts or review or investigation having been undertaken at all, to be held to be incompatible with Convention rights when there's a duty to comply with them. And so we submit that at the very least, and after the careful consideration in the preceding paragraphs, Mr. Justice Coulton was correct to reach the conclusion he did. See in particular the conclusions that he reached at 367 to 370 of his judgment at page 560. So we submit that the Act is set up to permit and enable an investigation which is compliant with Article 2, and that the powers that are conferred by it, and indeed the duties to which the investigator is going to be subject under the specific provision I've just mentioned, on no view preclude that sort of outcome. I wanted to pick up two particular cases that my learned friends, the respondents, relied upon, and they are Armeen and Jordan. Both of them will be very well known to the court. Armeen is at page 6556 and Jordan and the UK, the Strasbourg case, is at 9371. And in effect, what is being said by the respondents is that those cases stand as authority for the proposition that, in effect, the requirements of adversarial process with legal aid funding and all the rest of it, that the Court of Appeal identified as necessary, is a sine qua non of an Article 2 or 3 investigative process that is compatible. We respectfully submit they stand for no such proposition. The answer to Jordan and its identification of the absence of legal aid as a deficiency in that case is, if I can shortcut it, the one given by Mr. Justice Colton at paragraph 358 of the judgment, page 557. It isn't some immutable requirement that applies in all cases. It depended on the particular facts of the case. And there are different ways of setting up a compatible Article 2 investigative process that will be sufficient. There is a basic disconnect, we submit, between extrapolating a general rule on legal aid from Jordan and other cases and Parliament's fundamentally different set of choices under the Act. The role of legal aid in support of Article 2 investigations operates, at least essentially in those cases where it has operated, where the form of the investigation is essentially an adversarial legal process, classically an inquest, as in Jordan itself. That is a type of process which the next of kin may be unable to participate in without legal aid, with all the detriment that might flow from that. In contrast, a key purpose of this Act is to establish a new and distinct investigative body which will operate in large part inquisitorially and which does not carry out its processes. That is regarded by Parliament as a positive virtue, not a vice, which does not carry out its processes as if it were a set of adversarial court proceedings or a trial. And it simply makes no sense, we submit, to graft or to seek to derive a general proposition that applies in that context from the fundamentally different situation which was being dealt with in Jordan. And the ICRIR body will have the flexibility in how it goes about its functions, how it involves the next of kin. That doesn't mean it's got to permit them to cross-examine witnesses, which it is interviewing. Indeed, we know from De Silva in the Finucane case that if only De Silva had himself probed, that would likely have been sufficient to cure at least that deficiency. So none of that is fundamentally contrary to Article 2. It's reflective, rather, of its inherent flexibility and fact-sensitive nature. Armine also, the well-known Armine case judgment of Lord Bingham, also doesn't stand for any such approach. Lord Bingham, as you will recall, emphasised he did a pretty similar thing to what was done in McQuillan at paragraph 109. He did it in paragraph 20 of Armine, in those days identifying the key requirements of an Article 2 investigative process that was compliant. But essentially the language hasn't changed in relevant part. It's all about necessary to protect their legitimate interest, their relative ideas, sufficient public scrutiny, effectiveness being the moniker, all depending on the facts. And he cited for that purpose, amongst other cases, unsurprisingly, the Jordan case. So you can't extrapolate from that decision to some form of general requirement in effect for state-funded trials. That was a case, as you'll recall, about the murder of a young person detained in a youth offender institution by their cellmate, a classic instance in which an inquest would in those days have been the logical form of investigation. As you'll recall, the debate then, in those days and in that context, was much more about whether a Middleton inquest needed to be set up rather than anything else. And the court ultimately concluded in Middleton that it needed to be blown out to include the how question, or in what circumstances question. But that was sufficient. It didn't create, and is not authority for the proposition that under Article 2 the perfect must be the enemy of the good, in effect. That's the position we take in relation to Armine and Jordan. And in relation, just to come very specifically to cross-examination by people's lawyers, that our short submission in relation to that is that that has no monopoly on effectiveness. ICRIR can probe effectively we don't know because they haven't done it yet, but ICRIR can, in principle, probe effectively, and they have the variety of options that are currently being explored. And it's a point I made earlier. You'll remember I drew your attention to some of the passages in Mr. Justice Colton's judgment, particularly 353 to 356, from which you will see, specifically in relation to that probing by ICRIR, that not merely have they not conducted any investigations which would enable you to do the McQuillan looking back assessment of effectiveness, but even the processes that they are proposing to use pursuant to the discretion and the powers that are conferred under the Act are not set in stone. And at least some of those conclusions and some of those potential policies and approaches were explored by Mr. Justice Coulton, and you'll see what he says. Effectively, he says, well, you know, if those come in, that all looks good. That all looks compatible. But no one can know precisely how they're going to do that at this stage. But they are in principle, ICRIR is in principle, particularly under the, no doubt, the wise direction of Sir Declan, will in principle be capable of operating a perfectly effective mechanism or set of mechanisms for probing controversial evidence which may be obtained under compulsion or not under compulsion. So we submit in relation to that that the judgment of Mr. Justice Coulton was correct and the judgment of the Court of Appeal was not. Disclosure, if I can turn to that, two conclusions of the Court of Appeal that I wanted to pick up. And again, the Court of Appeal went further than Mr. Justice Coulton did. Mr. Justice Coulton's analysis, which we recommend, is at page 548 in the bundle, and it's paragraph 306 and following. But to focus on the Court of Appeal, conclusion one was that there was no provision requiring disclosure of material to the next of kin, 221 of the Northern Ireland Court of Appeal judgment. And my submission is there doesn't need to be a duty of disclosure in order to secure compatibility. There is undoubtedly an express power to do so. That power exists in section 30 sub 1, page 5305. And of course that power, unsurprising that it should be a power and not a duty, but that power is coupled with the duty to comply with the HRA in exercising the functions. See section 13.1, to which I've already drawn attention. So if you consider that the decision not to order disclosure is flawed on public law grounds, then no doubt that complaint can be raised. But my core point is that the power plus the duty to comply with the HRA, plus the right to challenge that in a JR if necessary, mean that there's absolutely nothing to prevent disclosure if that might be required by Article 2. That's the first conclusion. Second conclusion is, in summary, it was a collection of points, all of which were described as problematic or difficult. But the second conclusion is, in essence, I hope being fair to them, that the mechanisms for dealing with sensitive information were too restrictive. That's Northern Ireland Court of Appeal judgment, para 227 and following. And the overarching point that I make remains the same. How this might work on particular facts and what impact there might be to the effectiveness of an investigation or a review is a matter that can't be determined at this stage. What can be said at this stage with some real confidence is that there's nothing in the Act to prevent, in all or almost all cases, compliance because of such restrictions on disclosure as Parliament has seen fit to impose in the public interest. And I did want to just take you back, if I may, to the legislation to trace through the relevant provisions so you have them all in one place that bear on this disclosure issue. Section 5 is the starting point. And section 5 is at page 5249 in the bundle, if I can spin through these. And so the starting point is full disclosure to ICRIR. Everything goes to ICRIR. A relevant authority must make available to ICRIR such information, documents, or the material as it may reasonably require for the purpose of or in connection with the review function. Everything has got to go to ICRIR, and a relevant authority is defined in section 60 to include lots of state authorities, including the agencies. The power to disclose is in section 30, which I've already referred to. That's on page 5305. If you just flip forward to that, and you will see that everything having come into ICRIR, the next stage is, what does ICRIR disclose out? And it has a power to disclose any information held by ICRIR to any other person. That's the basic position. There are then restrictions placed by Parliament on disclosure into the public domain, and that is dealt with if you keep we can't really keep an electronic finger in, but if we go back to section 4 on page 5248, you will see the nature of those restrictions. Can I just invite you to cast an eye down section 4.1? Must not do anything which would risk prejudicing or would prejudice national security interests of the UK, would risk putting someone's life or safety at risk, prejudicial effect on criminal proceedings, and then drop down to sub 4 for provision about the way in which sub 1 operates in relation to disclosure of information, C, section 30, sub 2 to 9. So those are the basic grounds on which Parliament has concluded that it would be appropriate for ICRIR, which has got everything itself, so it sees everything, but disclosing out is a different matter for obvious reasons. It might put lives at risk. And the rules that govern a 4.1 read with 4.4, and that takes one back to page 5305, which is section 30. And you see that what section 30 does is to set out various prohibitions on disclosure by ICRIR at sub 4 through to 9. Can I just invite you to cast an eye down so you get the sense of them? Essentially, it's identified or notified sensitive information. I'll come to the definitions in a second. Sensitive information or protected international information. You see the categories. You'll see recognise the categories. There are various duties to identify and to notify in Schedule 8, starting at page 5478. But in terms of the definitions of those concepts, can you go forward to 5365, please? This is in section 60, which is the interpretation section, and just so you see them, page 5364, first of all, sorry if I said 5364, first of all, you see the definition of prejudicial information at the top. That's putting lives or safety at risk. Then protected international information is defined 2 boxes later, or 2 boxes later, on page 5364. And sensitive information is then defined at 5365. So those are the basic categories which are, as it were, protected, but there is then a system set up of permitted disclosures, including of sensitive information, and they are dealt with in Schedule 6. See in particular page 5457. Really, you need to cast an eye through 3 and 4 in particular. So 3 is disclosures to named persons, the named persons being those you see at sub 2 of paragraph 3 on 5457. And then there's disclosure more generally, pursuant to permission from the Secretary of State once the thing has been notified in paragraph 4, which I'll come to very shortly. So if you keep that page open, if you would. And I pause here because the Court of Appeal, as you will have seen, criticised particularly the idea that the Secretary of State has the final say, or a veto, as it was put in 234. And I wanted, just before coming back to Schedule 6, to note one point at the outset, which is that this aspect of the Northern Ireland Court of Appeal's reasoning is the totality now of how the respondents defend this aspect of the appeal. They're characterising the issue as one of practical independence, as they put it. But that emphasis, we submit, reveals the problem with their objection to the ab ante submissions. And we submit that there's a real difficulty with that in the light of the ab ante submissions. But the basic structure that Parliament has put in place in deciding what the prohibitions, the otherwise generally expressed power to disclose any information in Section 30 should be, are clear. ICRIR can see everything, so like a public inquiry, but unlike an inquest, it isn't limited to open material. That's an important point. It sees everything. It's like a public inquiry from that perspective. It's very unlike an inquest where it's all open material. You have PII, and PII is an exclusionary doctrine, as you know. The usual bases for public interest are identified in Section 4. There's then the definition of sensitive information, including by reference to who holds the information, a not uncommon technique. One thinks of Section 23 of FOIA, Freedom of Information Act, creating absolute exemption for material held by, for example, the agencies. And it extends beyond the agencies in the context of this legislation, engaging other parts of the state, including the police, but only those parts which engage in intelligence activities. So it's limited in the way that Parliament has decided. Parliament has decided what protection should apply in what particular context. And we submit that that's well within their legislative discretion in the context of Article 2. They're protecting important public interests. They've set it up in the way they've chosen to set it up. There's nothing antithetical about doing that, we submit. And we note also that even if there is, as it were, the prima facie prohibition, you've got the permitted disclosure regime. I've shown you paragraph 4 on page 5459, which hopefully you have open, and you see from that that the Secretary of State is subject to statutory rules. It isn't just an open-ended discretion to say no to disclosure for any reason the Secretary of State feels like. He's subject to a regime that's been laid down by Parliament. In particular, if ICRIR consider disclosure otherwise appropriate and so notify, under these provisions in paragraph 4, the Secretary of State must then say if he considers that disclosure is permitted or prohibited. But he can only say it's prohibited in the circumstances set out in paragraph 4, namely if disclosure would risk prejudicing or would prejudice national security interests of the United Kingdom. See para 4 sub 3.
And in taking that decision, is the Secretary of State a public authority for the purposes of the HRA?
Would be a public authority for the purpose of the HRA, would presumably be subject to JR, and without getting too far ahead of myself, there is then a set of provisions from paragraphs 7 to 11 of this schedule which allow for the matter to be revisited at the report stage if ICRIR want to do that. So they can go back, and there is then an appeal process provided for in the legislation at that report stage.
From the HRA, in any event, you'd be able to challenge on the sort of grounds discussed in U3.
My Lord, yes. Yes, I respectfully submit so. And I was going to refer to U3 for a slightly different reason, which is if you're asking the question, why in the first instance should the primary decision maker about this be the Secretary of State, you find the reasons based on democratic accountability and institutional competence from U3. Yeah. So we submit that there's nothing wrong with this. The suggestion appears to be being made throughout the Court of Appeal's judgment and in my learned friend's cases that you've got a great big setup under which the Secretary of State can simply turn around and say no. In fact, the position is much more nuanced than that. He's subject to a set of statutory rules. there's a limited basis on which you can say no, and that matter can be revisited and is subject to express appellate right in paragraphs 7 through 11 of this structure.
How about taking into a balancing exercise? I was at page 73 of the appellant's written case, paragraph 123. I was a little confused as to what you were saying, or what the appellant was saying in that paragraph. There's no legislative requirement on the Secretary of State, is there?
No, there isn't.
Take into account the impact on finding the truth of what has occurred.
My Lord, there isn't, and there isn't the equivalent of that you see in at least one of the criteria that are called to be taken into account, which is the allaying of public concern that one sees in section 19.5. Yes. You don't have anything equivalent here, but what you do have, we submit, is a situation which is not really comparable to the situation that you get in an inquest through PII, because you're set up in this special sensitive context with all the concerns that arise in relation to that. And the matter is ultimately subject to appellate right in the way that I've described, and could be JR'd. And no one is saying that the...
It's JR'd on judicial review grounds.
On judicial review grounds, but that wouldn't...
The of your argument in Secretary of State against Fee was that was that before moving away from the Secretary of State's assessment of the security aspects, it had to be established that it was both very unreasonable.
My Lord, yes. And I respectfully submit the same argument would no doubt be made here in relation to the challenge to the national security part of it. But the bit that you're raising is there a balance that is to do with justice? That would be a matter that could be raised by ICRIR, and if those circumstances were, because they've got to notify and the Secretary of State's then got to make a decision, and would have to be thought about by the Secretary of State, it would plainly be a material consideration. But very often, as you know, in the PII context, if there is a genuine national security concern, that tends to trump.
But it would clearly be, and there would be, in principle, a balancing under the when you're applying the procedural obligation under Article 2.
Yeah, my Lord, there would, and that duty we rely upon. But we also note, for good measure, that under the Justice and Security Act and Section 8, there is a similar sort of mandatory provision that says that a court, in considering a closed process, must not do anything that would trash national security or that would impinge on national security. Now, you ultimately may bump into an Article 6 issue there. That wouldn't arise here because we've got the comply with the HRA. So there are ways in which it will work. It's just been set up in this way in this legislation.
I just wanted to clarify that you accept by various means that a balance has to be applied.
Well, my Lord, if the matter is raised by ICRIR, and they say we think this is a thoroughly important document and we want to do it and we don't think there's a problem, then I'm not excluding the possibility that a balance would need to be undertaken, because the other side of the balance might be a material consideration.
I can come back to 123. I thought you conceded that.
My Lord.
It was an analogous problem in a way in U3, where the children's Article 8 rights were at stake, and because they had an interest in having contact with their mother, and the other side of the equation was the national security risks involved in admitting the mother to the UK, and the court, or rather, well, it was what's it called, the tribunal.
Yes.
Well, the tribunal there had to balance national security on the one hand against the children's Article 8 rights, in order to carry out the Article 8 paragraph.
And it didn't need a statutory provision for that. It just did that under the auspices of the convention, because that was what required. My Lord, yes, I respectfully agree. But my Lord Stevens is right. There is no requirement to do the balance, but there isn't, in effect, a requirement to do a balance under the JSA either. And no one has ever suggested that's problematic. And in a way, it's essentially non-problematic, because everything goes to ICRIR. Everything of relevance goes to the closed court. I'm conscious of the time. I don't know if Lord Wilson has very kindly agreed that I can carry on at least for a little bit of time, maybe in 5 or 10 minutes or so. Just wanted to finish this bit, if I may, gisting, which the Northern Ireland Court of Appeal expressed what they described as serious doubts about the ability to disclose a gist, for ICRIR to disclose a gist. I respectfully submit that that is not a good point. If you go back to section 30 sub 1, page 5305, you will see that the disclosure power in ICRIR is a power that is related not to documentation but to information. And the whole of this Act is set up on the basis of information. And so there would be nothing whatever to prevent a gist that wasn't problematic from a security perspective. Well, also we say that there is nothing inherently bad or incompatible in that scheme. It balances in the way chosen by Parliament. Ultimately, Parliament has the discretion, exercising the power of the state for this purpose, to make these judgments. It balances in the way chosen by Parliament the competing interests at play. It ensures that there is a reviewing body headed by an august senior member of the judiciary, ex-member of the judiciary, current member of the judiciary, who sees everything, or which will see everything, however sensitive, and it then allows for further onward disclosure in accordance with a detailed and nuanced legislative scheme, bounded, as the President has rightly pointed out and reminded me, by the positive and express requirement to comply with the duties imposed under the HRA in this legislation. And there is no European Court of Human Rights case that comes close to precluding a model of this kind, inquisitorial at its heart, but with all the efficiencies and the break from the past that that creates. Nothing to preclude a model of this kind in the Strasbourg case law. On the contrary, much of the Strasbourg case law recognises the importance of speed, efficiency, balancing these matters all together, and in the context of disclosure, I might add, has consistently recognised the need and the permissibility of a state to defend against disclosure on national security grounds. And so we respectfully submit that it is impossible to say that that statutory scheme, inherently or at all, still less in advance of any ICRIR inquiry at all, is incompatible with the Convention. And we would add for good measure, but only as a reminder, I'm not sure you need it in this case, but only as a reminder, I would add as a general proposition that this is potentially, even if there were doubt about that, this would be one of those cases where the principle in A, B and the Secretary of State for Justice might well be thought to have some purchase. That was the case, as you will recall, in which the Supreme Court reanalyzed or analysed again the Ulla principle. You have it in the bundle at page 11421. The key paragraph with the repeated phrase, the court should not go further than they are fully confident that Strasbourg will go, is at paragraph 57, but the section of analysis runs from 54 to 59 in AB. So one has that if necessary. I wanted to turn in the time remaining to remedies and or disapplication.
Can I just check, are you eating into your reply time, or is Lord Wolfson sacrificing his own time?
My Lord, at the moment, I'd rather leave that debate unsaid until my Lord has disappeared from court, and I can bully Lord Wolfson as much as I'm able ever to bully Lord Wolfson. But not sure, but we will make it up somehow between us.
Right, okay.
Maybe thought to be pretty unsatisfactory for him to start at the end of a long day anyway, but there we are. Remedies disapplication, the final topic. I'll take it shortly if I may. We're interested in this issue not least because of the very serious concern that's already been referred to about the wide range of ECHR incompatibility and or breaches of the HRA that on the other side's case, it is now said, can be characterised in Northern Ireland, brackets in Northern Ireland but not in Great Britain, as breaches of the Windsor Framework and therefore said to require immediate disapplication of legislation. and you've seen examples, both this one and the Illegal Migration Act, of some very, very real controversy, with all the ongoing controversy that appears to be bedeviling the Northern Irish courts. And it links rather to my bridge set of submissions between mine and Mr. McLeanan's there, because this is really an issue about remedies under EU law. That's what I'm going to be addressing. There's no doubt about how the power under Section 4 of the Human Rights Act works. It stands in sharp and stark contrast, we submit, Section 4 of the HRA and those balances in the HRA, with what is now being said is the sidewind effect of all of these documents, which is to allow the courts, through a very discreetly marked door, it has to be said, to disapply immediately primary legislation. Two questions. First, is there any discretion in relation to disapplication in such a case? Secondly, if so, how does it apply here? On the first, we submit that there is a discretion in the court. Article 4.2 of the withdrawal agreement refers to the need for there to be powers of the judicial authorities in the UK to disapply inconsistent or incompatible domestic provisions, as it's put in the withdrawal agreement. And that is expressed in terms of power, not duty. But I recognise, of course, that it's primarily directed at ensuring that the requisite powers do so exist, and that we say that Section 7 capital A of EUWA has provided for that, and all agree about that. And we recognise also that the standard formulation for the CJU is that national courts have an obligation to disapply domestic legislation which is inconsistent with directly effective EU law. So that, we recognise, is the starting point. But it's also important to recognise, we submit, the very particular context in which this issue arises. In other words, from a very specific aspect of the withdrawal agreement under Article 2.1 of the Windsor Framework, a provision which is uniquely framed by reference to the Belfast Good Friday Agreement and has nothing really to do with EU law at all, and does not carry the oversight jurisdiction of the CJU. In short, if ever there was an aspect of the withdrawal agreement regime in which there was scope for greater remedial flexibility, it is this one. But I wanted to build the principled answer to that first question on the Chester decision. In other words, is there a power? Chester is at 6680. And it was to do with prisoners voting, as you will recall. The Supreme Court considered the remedy, or the majority of the Supreme Court considered the remedy, the EU remedy point, on the basis that, contrary to the primary conclusion that they reached, there had been a breach of EU law. So they were doing it in the alternative and contrary to the primary conclusion they reached. So it's an obiter part of the judgment, but that matters not. The EU law analysis, in general terms, was there a breach of EU law and so on. That starts at paragraph 43, but the key bit for present purposes is paragraphs 72 to 74, starting on page 6724. And can I invite you just to cast an eye down those paragraphs? You probably don't need to read the passage within 72, which is below the quote from the unpronounceable case that starts 72. This is only that first line of the quote that is picked up later in the analysis. So if you read that bit of 72, then 73, then 74, that would do it. So you will see the nature of the analysis. The disapplication power under EU law applies, quote, within the limits of the court's jurisdiction. That's the principle they took from the quote at paragraph 72. And they applied that in the final or the penultimate sentence of paragraph 74, as you will have seen. And that what the Supreme Court then did was to treat the constitutional considerations, indicating in that context that the solution was for Parliament under our domestic arrangements and couldn't be done by a court, as being within that concept of domestic jurisdictional limits. And they held on the facts that to redesign prisoner voting was outside the court's constitutional function and jurisdiction for the reasons that they gave in paragraph 74. But we submit that that answers the question, is there a power ever to do it? And the remaining question is how that works here, if there is a power to do that. And we respectfully submit that similar reasoning and the same conclusion as was reached in Chester applies here. We are dealing in our 2023 Act context with a piece of legislation designed to cover a range of matters to do with legacy issues. There are lots of interrelated bits to that legislative scheme, with a variety of incompatibilities having been found. There's a range of potential solutions to be considered. All of this in this controversial, highly controversial area is paradigmatically a matter for legislative choice on a controversial and complex area of social policy, and one could add, with significant international relations implications, especially perhaps with the Republic of Ireland. And in those circumstances, we submit that it isn't for the court, and wouldn't be for the court even under EU law, to quote from paragraph 74 of Chester, to devise an alternative scheme that would or might pass muster in a domestic or supranational European court. And so we respectfully submit that all of those themes and features that underpin prisoner voting and the reluctance of the court constitutionally to engage with that and to redesign the world apply here, and perhaps apply a fortiori here, given the nature of the complexity with all its international ramifications. So that's the way we put the disapplication point. If we get there, we respectfully submit there's quite a few hurdles that have to be overcome to get anywhere near there. But those are my submissions, and with thanks to Lord Wilson.
Thank you very much, Sir James. Well,
It's not immediately clear to me that my nod objectively construed is actually gifting Sir James my time. But that's a point of contractual interpretation which I hope the court won't be concerned with, because it's all secretaries. May I stop my submissions in the morning?
yes, of course. We'll look forward to hearing you at 10:30 tomorrow.